Okay, good morning. Welcome to the Sandcastle again for some folks. My name is Jimmy Bailey, the Chief Operating Officer of the Community Association. I want to welcome you here. I also, again, would like to welcome the folks that are participating over the internet via Kika's live stream channel. As I mentioned last week, this is something that we're very pleased to be able to offer now to provide folks who live somewhere else most of the time the opportunity to be a part of Kika meetings or Kika events. And so our ability to close that distance dramatically between where folks are and Kika is something we're proud to be able to do. And again, want to thank our IT folks that put in the hard work to make that possible. Also want to mention again that if folks are not able to be here in person or participate on live stream, that a video replay of this is available within hours after we finish on Kika's website. So this morning will be slightly different from last week in that I won't bore you with the long introduction that I gave. It'll be somewhat abbreviated. Our assumption is that most folks here are at least familiar with the topic. And we'll reserve the bulk of our time for your questions, comments, etc. But like last week, I'll make a few comments. Dick Fishburne with the Conservancy will do so, and then we'll open it up for questions and comments. I am going to keep the microphone on, mainly for the folks on the live stream. I wouldn't need it for this small crowd, but I do want to make sure that they can hear. So, again, I think most folks are familiar with what we're here to talk about. And this is a proposed land trade between Kiowa Partners and Community Association and the Kiowa Conservancy. And the main point that I want to open up with this morning is that a lot of people have spent a lot of time working on this deal. It is admittedly complicated. There are multiple moving parts, multiple entities. And so it was a negotiation that took quite a bit of time to put together. But at the end of the day, once that there was a deal in place, your fellow homeowners, the elected leaders of the Kiowa Property Owners Association, meaning the 5 property owner elected directors, the 21 trustees of the Kiowa Conservancy, as well as the town council and mayor, every single one of them that studied the facts concluded that this was a good deal for Kiowa. And as I said last week, the reason why we think it's an outstanding deal and the reason why we were able to get through such a difficult negotiation is that we weren't looking for something that was just good for Kika or just good for the Conservancy. We were looking for something that was good for Kiowa. And so we think we've achieved that. As I said last week, it's hard for us to come up with reasons to vote no. But I would like to now turn it over to Dick Fishburne, who he's been working on this for a long time. Some of the parcels that will be preserved if we vote yes are parcels that he's had his eyes on for close to 20 years as a volunteer at the Kiowa Conservancy. So, Dick.
Thank you. Is the microphone on here?
Yeah.
Let me see.
Okay. What I wanted to do is to share with you some of the interaction that we have had with the community over the last 2 weeks while the voting has been taking place. This is the 7th Q&A session that the Conservancy has had with the community. And we have had a number, as you might expect, of interactions that are more informal, where people have contacted a trustee or they have had something on part of the social media. What we have discovered is that there's a different type of question that you get, or comment that you get in a large meeting like this than when you get in a small meeting. And the largest difference that the leadership team of the Conservancy has noted is that there is one word that you never hear in a meeting that's large, because it's the elephant in the room. The word is trust. And what I would say is negotiations aren't about trust. When you go to buy a new car, do you trust the new car dealer to give you the best deal? Of course you don't. You know what's important to that car dealer, and you know what's important to you. And you have to negotiate in a manner that makes the situation best for you. You got to understand the size of the value that's available to you. It's best if you work together to make the value larger, and then each of us try to get as much value as we can. That's the way the process of negotiation works. And if you get a really good negotiation, most people would say you gave away something that you really didn't want to give away at the end. Not a big thing, but something that you really believe in. So now we're into the end of the negotiation, and we come back to the issue of trust. The Conservancy and the Community Association are saying that we have, and the partners have said, we have placed a covenant in the agreement that says you cannot have vehicular access to the spit. At the meeting that was held last Thursday, one of the community members said, would you be willing to amend that any change to that covenant would require a vote of the town? The Community Association and the partner agreed to that, and that agreement has already been written. This is not about the spit. This is about the entranceway to the island. Now, who are you going to trust to say that that statement is true? You have 21 trustees on the Conservancy and a host of trustees before them that have looked at these issues and says, yes, that is what it is. You have 5 individuals who you elect to represent you on the Community Association who have said, yes, that's the way it is. You have a town council of 5 elected members who have said, yes, the way it is. You have an environmental committee of the town whose 7 members last week said it's an environmentally positive situation. You have other members of the entity, the resort, the real estate, who have looked at this over a period of time and say the entranceway is the most valuable developable parcel that still exists on the island, and we need to protect it. You have the South Carolina Department of Natural Resources that says this is worth protecting. You have the U.S. Fish and Wildlife that say this is worth protecting. We've had discussions with the other conservancy groups that protect conservation easements on the north side of the island. And they say this is a great thing that you're doing, and when you get a positive vote, we want to talk about how we can work together to have environmental impacts that are good for Kiowa. Those are the people, and you know them as neighbors, who are saying that's what the situation is. Now, some of you have probably seen last night that the Coastal Conservation League has come out and said, we recommend you vote no. Now, I've been involved in conservation for 30 years in top-tier environmental groups like the Nature Conservancy and the Audubon Society will tell you in Conservation 101, when you're a national or regional environmental organization and you're dealing with a local issue, the first thing you do is call the local environmental agency and ask them for their thoughts. They never did it. So what due diligence did they do on this particular issue? They have an interest in Kiowa, and that's the legal suit that has to do with the spit. And there are multiple people in this audience who hope they win. This is not about the spit. In addition, the Coastal Conservation League trashed the preservation of marshlands and marsh edges that exist around Kiowa. And by extension, every place else in South Carolina. So they dissed every environmental group that exists across South Carolina. So when you come back to this issue and you begin to think about, do you have all your questions answered that allow you to make the decision that you want to vote? And you've heard everybody say, this is a democratic process and the most important thing is the vote. We hope that you will listen to your neighbors who have spent a lot of time thinking about this and who have said, this is not about the spit, it's about the entranceway. The next thing that I would ask you to think about is you can make a value judgment about what the most important thing that's undeveloped is to protect. Unless you change your mind, Marilyn, I heard you say last week, you think protecting the 4.6 acres and having it stay in its natural state is the most important thing for you. And the Conservancy respects your opinion because that property has a lot of value for you. Now the Conservancy could have made that decision among itself, but what it decided to do is, we don't want to make a decision that involves 21 trustees of the Conservancy. We think this is so important to the town that everybody should have a chance to vote. And that's why the vote is being taken at the town level. So we would like you to make sure you're comfortable, that your questions are asked, and then please vote. The Conservancy would also request that when you decide how to vote, you take the conservation aspects and the importance of the entranceway to you into account when you decide how to vote. And as Jimmy said, at this point, we're going to open it up for Q&A.
Thank you, Dave.
I don't think this is on, Jason.
Thank you. Wendy Kulick, 38 Marsh Edge Lane.
Boy, you got one that's a lot better than this one. I'm going to exchange this.
First of all, I want to thank you again for holding a Q&A. Some of the people here may not have been able to either be present in person last week. Some of the people on the phone may not have been able to listen in. So I think it's a good thing to do that. I also want to again, as I've done online, on the Town Exchange and on iKiowa, I want to urge everybody, regardless of how you cast your vote, please cast your vote. If we don't get a quorum this time, the next time that this is put before property owners, there will be no minimum required. And that could mean that a few people get to make a decision for all of us. I think we all need to take advantage of the opportunity to vote, and I again urge everyone to do so. And if you think of the old Prel commercial, you know, I told two friends, and she told two friends, and she told two friends, get the word out of how important it is to vote. I have both process and substantive questions, and some of them are from property owners who are not able to be here, and therefore, even if they're listening in, they're not able to ask the questions. And I think that's unfortunate, but I ask these questions in no particular order of importance. This Q&A has been scheduled again during the workday, making it difficult, if not impossible, for off-island property owners or property owners who live here to participate? Did Kika give any consideration to scheduling a meeting in the evening or on the weekend when more property owners may be able to participate? And if not, why not? And why not make these sessions interactive so people who cannot be here are able to ask their questions?
So, as I said last week, it's virtually impossible to pick a day or time, really any day or month during the year, that is convenient for even a majority of our property owners, considering the fact that 80% or more live elsewhere. It's just a fact. We have tried every trick in the world to build attendance at various meetings. In fact, one session that's a regular meeting, a couple of years ago, we moved it to the Friday prior to Celebrate Kiowa, thinking that perhaps that would boost attendance. It just depends on who we're talking about with respect to, young families like to come in the summer, retirees like to come in the winter. It depends. And so the live stream capability has closed the gap. It is relatively new for us. Our IT staff has done a fantastic job making it available, and they continue to work on ways to improve it. We have looked at systems that are potentially more interactive, extremely expensive, but this is, again, it's new for us. I would say that if you compare what Kika provides in terms of accessibility to participate in a forum like this, it meets or exceeds anything that I've seen from certainly any governmental agency that I...
Oh, don't do that.
Well, so that's my perspective.
Okay, it's clear from Dave Singer's email yesterday that Kika has not yet received enough votes to achieve the quorum requirement. What is the percentage at this time, please?
So I can tell you, I'll give you two numbers. We're able to look online and see how many votes have been counted. Obviously, an electronic vote that gets cast over the internet, that happens instantly, but a number of people vote by paper ballot as well. And the voting company in Florida enters those as they receive them. As of yesterday, we were at approximately 31%. The voting company informed me that they had received about 400 ballots in the mail that had not been added to the tally yet. Now, how many votes are included in those 400 ballots is anyone's guess. Gracious. But my guess is we are getting close to 40%, but I don't know.
Okay, thank you. Related to that question, I'm not on all social media, but I am on Facebook, and I looked at a number of the social media platforms on which Kika participates. Why not use those platforms in addition to any other means to emphasize how critical it is that we achieve quorum? Because I've seen please vote, but I haven't seen the implications of if you don't vote now, what happens? And so I would encourage Kika to use those platforms, not just to say, please vote, but to explain the ramifications if we don't achieve quorum.
Certainly. I don't know if that was a comment or a question, but we utilize...
It's a suggestion.
We utilize email, website, social media, text message blasting, mobile app, push notifications, and a host of other digest, etc., and we'll keep doing that. I can assure you that every time we have an election, whether it's for something like this or for directors or anything else, the last thing, at least the staff, the last thing we want is a second election, because it is all consuming for more than 30 days.
The other thing is that I haven't seen, unless I've missed it, I haven't seen an e-blast from Kika talking about the importance of quorum. I believe that goes to a lot more people than the number of property owners on either IKEA or the town exchanges. And again, I just encourage you to use every possible avenue open to you to reach as many property owners as possible.
I agree with you, but we do our best to try not to overwhelm people as well with too many emails in a week.
I understand.
Last week, I think we had 3 of them because of announcing, please come to the meeting, etc. Our open rate on the first email was about 48%. Our open rate on the third email was under 30%. And so we recognize that when people get hit constantly, they're less likely to read.
Excuse me. You want to see if you can get it to stay? While you're doing that. I've spoken with a developer from New York who indicated that there could be no tax write-off to the partners without first having an appraisal determining the value of the property. As some of you know, my husband is a real estate agent with Akers Ellis. He advises all of his clients that they should never make an offer to purchase a piece of property without having seen an appraisal first. So if the partners are going to take a tax write-off for donating these properties, how can they do so without first having gotten an appraisal of the property to be donated? How do they determine the value of the write-off?
You'd have to ask the partners that question.
And there's nobody here from the partners?
Townsend is back there.
You can get an appraisal after the fact, as of the date of the transaction, so you don't have to have an appraisal done before it actually occurs. We were waiting until after the transaction to get it appraised. We did have the figures, if you'll remember, 7 or 8 years ago appraised those ones up there, but that appraisal would be outdated.
And what was the appraisal then?
I can't remember. I don't know if it's $1 or $2 million for those first 2. It might have been more than that, so I'll retract my $1 million.
Okay.
That was a long time ago.
Thanks, Townsend.
Wendy, if it adds any information, there was a parcel that sold across the street where what many of us call Little Rabbit is over here, and if I remember the number that is in the records, it's north of $3.5 million
That's correct.
for a parcel that has 14 properties, and these 3 properties are zoned for 44 properties.
What is the height, maximum height on Little Rabbit Island before building? Because that would make a significant difference. As I understand it from the Q&A last week, Kika has not asked the partners, and they have not offered to abstain from voting on this land swap. And I believe the number of votes they had to cast was 260. How is this not a conflict of interest for the partners, and why hasn't Kika asked them not to vote their votes?
Covenants allow us to vote, and this is an important issue.
That wasn't my question, Townsend.
I know, I'm going to get to it. And we are property owners on this island, just like everybody else. We have a vested interest in this island, just like everybody else does, and we're going to vote our votes.
But the financial vested interest is exactly why they should not be voting. So with all due respect, I disagree with you on that. And that doesn't answer the question about why Kika hasn't asked that they recuse themselves. The partners have always, and this goes back to when KRA owned the land, the partners did not vote in property owner elections, letting other property owners make the choice. And I would just ask Kika to consider that in this. In assessing the comparative value of the parcels to be swapped, did Kika take into consideration the fact that the value of the property already owned by the partners behind the 4.62 acres becomes more valuable with the addition of the oceanfront parcel? It too could then be sold together with the KIC acreage as oceanfront property. If this was factored into the equation, Could you specify how? Why did Kika think it unnecessary to have the parcels appraised? Is the 700 acres of marshland buildable? If not, why does it matter whether it is donated to the Conservancy or not?
I'm sure you will remind me if I forget any of those 4 or 5 questions, I think, that were in there.
Probably.
The first, I believe, was, did Kika consider the impact to the value of the parcel next to the 4.6?
Well, the surrounding parcels that the partners already have the right to develop. And nobody's questioning their development rights.
I think that what Kika considered was, what can the community gain from this transaction, and how can we maximize that gain? We have a fundamental difference that I acknowledged last week on this issue of appraisals. And we've said it repeatedly that we never viewed this as a balance sheet transaction. And that we believe that the value of what the community gets out of this far outstrips any financial gain to the developer.
So let me answer this from the Conservancy perspective. There are 2 ways that you determine a financial value of a property. You go talk to a real estate agent who looks at comparable sales around the area, and they come back and give you an estimate of the value of that particular property. The advantage of that process is it doesn't cost anything if you have a friendly sales agent that can help you out. In the 20 years that the Conservancy has been looking at conservation easements, that's the methodology we use on the front end of the process to understand the value that's associated with a property. If we are going to proceed to the transaction, we do a full market appraisal to make sure there aren't deed issues or something of that particular nature.
So what did the real estate agent tell you it's worth?
What's the if?
You said you go to a real estate person and they'll give you the value of that property. And
So
you said
there's-
you've already done that.
So there's multiple parcels, there are multiple parcels that are involved here. The value on the comparables analysis of the 4.6 acres
Right.
was between $8 and $12 million, depending on how you ended up looking at it.
Right.
The Timbers property, did you go to that one, Jimmy? So the parcel that we are talking about is the dark pink, and the 4.6 acres in total includes the pink and the dune line down below it. Our assessment was $8 to $12 million based on the analysis, and you have to go into some of the issues that Wendy's talking about of, do you add it into it, do you reconfigure it in terms of how it's going on? The Timbers property, what's in green, which is about 60% larger than the property in pink, sold for $10.9 million. The comparability analysis that we did on the 2 parcels, if you can go back again, in yellow, we took the property directly across the street that has 14 properties, sold for $3.5, $3.7 million. These properties are at comparable size, and if you can see the chart, it says you can build 25 single-family homes on that property. We've seen the plat of the property. We've also done a market assessment on the bottom and had numbers ranging from $2 to $2.5 million. So if you add the 2 numbers together on this, you get into the $8 to $10 million range, and you get the $8 to $10 million range on the 4.6 acres. So the developer has an interesting choice in this particular regard. They can get revenue from the 4.6 acres, $8 to $10 million, or they can get property into entranceway for $8 to $10 million. What the community is being asked is, which of these would you prefer they go after? And I'm going to leave it with Wendy because she has the floor. from a process perspective.
Absolutely, thank you, I appreciate
Wendy,
that.
I think your next question was about the area here in Green.
The 700 acres, yes.
And what I can suggest to you is, at least from Kika's perspective, if this was the deal, we wouldn't be standing here. I mean, we believe this has value, but we wouldn't be standing here presenting this deal to you if this is what this was about solely. But as we went through this process and said, how do we create value for the 1.7 acres of developable land down by the beach? You know, we identified the fingers, we identified the operational parcels, but we also asked for other things that we felt like we could get. And based on our discussions with the Conservancy and with the town's environmentalists, they talked to us about the extraordinary value of this property from a research perspective and being able to control those decisions here on Kiowa as opposed to somewhere else. So this is a part of this, but we're not presenting this proposal based on this 700 acres of marsh. Can you build anything on it? I would say probably not on any of it, but certainly there are a few hummock islands where you see up and down the intercoastal waterway where little things get built, which I don't think anyone would want to see in their sightline approaching the island.
But again, since it probably, almost certainly, is not land on which things can be built, throwing this in as part of the deal is part of a red herring. The developer isn't really giving anything up because it's not going to be developed.
There are a lot of land trusts in this country that disagrees with your comments. They've had experience with people saying exactly what you're saying. Don't worry about it because it's never going to be developed. And then somebody comes along in a new governmental agency, particularly at the state level where you don't have as much control, and says, oh, you can build a boardwalk over to there. One of the other parcels that's included in here is a 7.7 acre hummock island near Bass Creek. You don't have to have a large imagination to see the boardwalk over there and a couple of houses being built. There are multiple situations around the country where people have said, you can always do research on this particular land. And then they discover you can't do it. What the Conservancy doesn't want to do is be sitting in front of the town 15 years from now and having the town say back to us, why didn't you do some research on this wildlife species? And the answer would be, well, we always thought we could do it, but people changed their minds. This is a down payment on protecting the island. Why is there 1,800 acres in the rest of the watershed that have been protected by some of the best conservation organizations in the company? Because they believe marshland and marsh edges are really, really important. We have a difference of opinion on that subject clearly from you.
And again, I would just point to the fact, I mean, if you look at the map of the island in its entirety, you know, this page and then the next page, there are a variety, as you know, a variety of exchange parcels proposed. And if it were only the 700 acres, we would not be here asking you to vote for it.
Thank you. How much has the Conservancy spent on the brochure it sent to all property owners? And I saw there were a number of them at the back of the room. And the meetings it's holding off island, like the gathering at the Duke Mansion this past weekend. And is Kika contributing anything to either of these in terms of staff time or money?
The answer to that question is no. And the answer to your first question is $5,000. And it's primarily related to please vote.
My next question, I'm not sure there's really an answer to, but I need to ask. From the very beginning, after the court ruled that Kika, in fact, owned the 4.62 acres, and it was not a scrivener's error, as alleged by the developer, once the judge ruled that way, from that very point on, in digest, in other communications, Kika has said this land has no financial value to Kika and its members because it's landlocked. Right now, it is landlocked. State law also requires that a property owner be given vehicular access to his or her property. I would say, of all the emails I've received from property owners who couldn't be here today, and it's probably at this point in the neighborhood of 35 different emails, one of the constant recurring questions I get is, why did Kika say this from the beginning? When the judge ruled, why didn't Kika go to the town planning commission, ask it to rezone the property so that another sandcastle facility could be built there, and then the developer would have been required to provide vehicular access? And I don't know the answer to that question. I don't know if you do.
I'd be happy to answer that question. So, and let's work in reverse. First of all, let's talk about a sandcastle on that property. Right now, here at this sandcastle, to accommodate a 12,000 square foot building and a pool and so on and so forth, we take up just about every square inch of the 4-ish acres of developable property here. So it's inconceivable to think that anything even half this size would fit on the developable portion of that property, and also handle all of the parking requirements and buffer requirements and so forth. To your point about access, Wendy, I believe that you are right that Kika could get access to the property. The developer disagrees with that, and we're convinced that it would result in a legal battle over that issue. Now, whether Kika would win it or not, I don't know. I feel pretty good about that, but we know that the legal system, you just never know. The second issue is, and the bigger issue, is development rights. We are absolutely confident that trying to acquire development rights that are given to them by development agreement would result in a long, lengthy, expensive legal battle with the developer with, we've discussed with legal counsel, and their opinion on chances of success is, well, I'll keep that between us and legal counsel, but it's unknown. And so, based on those set of circumstances, we do believe that the property has very little value, if any, to the community.
So let me add to that comment, and excuse me if I seem like I'm trying to have my voice be loud, because you know my microphone isn't working most of the time, so I'm trying to make sure the people in the back have an opportunity to hear. It's unfortunate that words like "it has no monetary value" have gotten out into the public domain. The reality in a piece of property is there's two types of rights. There's the ownership right, which who has the deed, and the development rights, who has the development rights. When you have a parcel that has ownership rights with one party and development rights with another party, neither has any monetary value for the property. You only create monetary value when you bring them back together again. What that property has today is conservation value. So if you believe the best use of the property is to have it be conserved, the 1.7 acres, then you ought to vote no and keep it as a property that is going to be natural in its life, and accept the fact that you're going to be looking at buildings when you enter the island.
Thank you.
Marilyn Larrick, 1082 Terrapin Court, Sparrow Pond. And I thank you, Dick, for noticing my postings last night about the Coastal Conservation League. I have a question for you. Do you consider the Coastal Conservation League a conservancy organization?
Yes.
Okay. And do you think they might have some ability to understand the implications of deed restrictions?
I think they have the ability to understand the implications of that. What I can tell you is that they never had a conversation with the Conservancy.
Okay, so I just wanted to state by reading from the actual statement, since not everyone reads the town exchange, what the Coastal Conservation League said. They said a deed restriction is the least ideal method of land protection, and more importantly, in my opinion, deed restrictions are not permanent and can be easily changed in the future. So your contention that this has nothing to do with Captain Sam Spit and its protection is something that the Coastal Conservation League does not agree with. Do you agree that the Coastal Conservation League has been instrumental in fighting against the development on Captain Sam Spit?
I have been the chair of the Habitat Committee for 6 years. I've never had a situation where the Coastal Conservation League has ever asked a question about anything related to conservation on Kiowa except for Captain Sam's. I appreciate the fact that they have taken that issue on and have said that there are many people in this room that would hope that they are going to be successful. They have one issue that is important to them, and that's Captain Sam's. And the question I would ask all you to think about is how interested are they in the entrance experience to this island? And are they willing to sacrifice a win in court for the experience that all of us has when we enter the island?
So do I understand then, Dick, that the Kiowa Island Conservancy position is that protecting Captain Sam Spit is not as important as protecting the Three Fingers north of, I think it's north of the Kiowa Island Parkway entrance?
The issue is that protecting the entranceway is an issue for August and September of 2017. There are going to be a lot of opportunities to have discussions about the spit in the future. If we vote no, and you want to look at what the worst possible case is, you vote no, the courts prevail, and the developer builds on the pink. They then build on the entranceway, and they then build on the spit. And all of us would be complicit in allowing that to occur if the opportunity, as Wendy so clearly has said, to exercise the democratic process and decide whether you want to vote yes or no on this decision.
So the Kiowa, let me go back a little bit. When KPOG, when the Kiowa Property Owners Group dissolved, we donated our residual assets, which were substantial.
Can I give the number?
I believe it was $46,000?
46 and change.
That's correct.
And at the time, I don't remember whether you were part of the meeting when eventually we all were able to get together to express our wishes as to what was going to be done, what we would like to see have done with that. And what we requested was research on the value, on the assets of Captain Sam Spit and the area surrounding it in terms of its wildlife value. I haven't been fortunate enough to get a report back from the Conservancy, and I know I was told that you weren't sure whether you'd be able to do that research because you weren't sure that you'd be able to approach the partners to ask them for permission to go on their land. So did anything ever happen with that? Because to me that begins to give me some signal as to how valuable the Conservancy views Captain Sam Spit. And I think Kika property owners, some of whom do value Captain Sam Spit and it's being preserved forever in its natural state, would want to know what the Conservancy thinks about that.
Well, as many of you are aware in the room, the town conducts an enormous amount of bird research on the island and has done it for a large number of years. Aaron Gibbons and his team goes out in the particular time and puts net on and catches birds and bands them. They start at 4 o'clock in the morning. They have a team of 4 or 5 interns that go out and do that. They've extended that to the eastern end of the island at the request of the Conservancy to continue to get this additional information. The Conservancy supports that research by providing the space that the interns use when they come in and do the research. Many of the trustees on the Conservancy host these people for dinner, because as you can imagine, 23-year-olds that are not getting paid like to have a free dinner. So the Conservancy is very aware
Beyond
of the bird
birds.
importance of the island, and it is also aware of the issues that exist on the river. A number of our trustees have deep concerns about that issue, but at this time, I will repeat, this is not about the spit today. It's about what you have an opportunity to make a decision in August and September of 2017. If we let the entranceway go and it becomes developed, we can't get it back.
And if we let Captain Sam's spit be developed, we can't get it back either. Thank
I
you.
think I agreed with that comment.
And I believe we were asking for research on all the other entities and all the other living things and habitat on Captain Sam's Spit, not just the birds, as much as I love the birds as much as you do. Thank you.
Just want to make one comment on the deed restriction. As Dick pointed out in his opening comments last week, a member of the association asked how could that deed restriction be changed in the future. And I stated at that meeting that I felt like that given the fact that if this is approved, it's approved by a vote of the membership, that a vote of the membership would also be required to make any changes to the deed restriction. But we went back and we have added the following language to the deed restriction that says any removal or amendment of this restriction shall require the affirmative vote of 3/4 of the votes cast at the duly called meeting of the association, subject to the quorum requirements for a regular or special meeting of the corporation as defined in Article 3, Section 6 of the Declaration, making it crystal clear that there won't be a little group of folks going and changing the deed restriction, that all of you would have to do that. But this, it does not, the deed restriction really is not necessary. It's there as an abundance of caution. The biggest issue that we keep talking about with whether or not Captain Sands is going to be developed or not is the access road. And if you look at that yellow line, that is the platted access road. That's a 50-foot wide right-of-way to Captain. This is an approved plat. The problem with access and the problem or potential problems for that road are much farther to the west than the piece of property we're talking about. In fact, if you look at that map, I mean, the area to work with around the 4.6 acre parcel is as wide as any place on that along that access route. So it's just not about Captain Sam's Spit. I was disappointed in the mailer from the Coastal Conservation League, but I was not surprised. I mean, they have been in court for a decade or more with the developer and are opposed to anything with their name on it. And so, again,
I have a question. How, once we no longer own that parcel and once, say, the developer sells that 4.62 acres, how does Kika have any rights over what that deed restriction continues on once it's exchanged hands again?
deed restriction runs with the land.
But the deed restriction is going, I would be interested in, did you get a legal opinion from your lawyers that this will continue even after it's sold 2 or 3 times?
I think that is a basic tenet.
I'm not a lawyer, as you well know.
I would also add, and I think I haven't mentioned at this meeting, but we have mentioned in a number of meetings, and we have this out in writing, that when the trustees of the Conservancy had this discussion, there was a long discussion among that group that if this particular transaction did anything to increase the probability that we would be able to develop the spit. They didn't want anything to do with it. And that was a condition of the Conservancy's participation in this particular process.
Good morning.
Morning.
Mike Jones, 1233 Kilo Beach Drive in Greens Lake. We watched the presentation, the last presentation online. We weren't down here. Thought you guys did a great job, first and foremost. Appreciate your efforts to get just the information out there. Since we've been down the last day or so, we've tried to actually figure out, and I apologize for this basic question, but we're trying to understand when we go down to the beach area, exactly where the pink is. Can you show us on there where, for example, the club's access point is, where the beach walker access gets to the beach, that kind of thing?
So you're familiar with the Beach Walker Park
Yes.
boardwalk?
Yes.
That runs
Yeah.
roughly along the side of the parcel and partially through.
So it is on this parcel?
Yes.
Okay, and then I guess my question,
This, if you come up afterwards, this dotted line right here,
uh-huh,
that's the boardwalk.
for the club.
For the people on Beach Walk.
Oh, okay, where is the club access?
Roughly somewhere in the purple.
Oh, okay, so off the property. Okay, then I guess my question is with the, releasing this property, what would happen to the Beach Walker Park access at that time?
It'll likely get, well, it ultimately depends on what kind of development activity happens here, but it'll get either left in where it is now or relocated somewhere in this general area, probably right to the west of the pink parcel. But
Okay.
there's an existing easement that applies to the entire 10-mile strip of dunes that allows for construction of boardwalks and things of that nature.
Okay.
Yeah, it just, if I could add just to that point, if you're trying to locate it, one of the confusions that occasionally occurs is you hear 4.6 acres and you hear 1.7 acres.
Yes.
The 4.6 includes the pink, which is high ground developable, and 2.9, which is the dune line that is not developable. And in fact, the dune line from everything to the east of this already belongs to the community association.
No, it doesn't.
Okay, the other question, what type of building restrictions are on those lanes, including the purple, for the beachfront? My concern obviously would be more 5-story high-rises going in down here.
So the zoning that applies to everything in purple as well as the pink is R3C, which is just a term in the Town of Keel Island zoning code. Now, if you want to get very technical and understand every single possible use and heights and buffers and so on and so forth, you can look it up online or you can meet with a town official. But essentially what that means is all of that purple area can have development there and likely will have development there that's relatively dense, consistent with what you're seeing down there right now. So I think it's a 4-story maximum, but I can't remember. So the point is you're going to see that type of development happen in this purple. And Kika continuing to own the area in pink is not going to stop that type of development. Whether you like it, dislike it, or don't care, the fact is that's going to happen all in this purple.
4 and 5-story high-rises. Okay.
I believe that the rest of that area, and that is the whole point of the whole case with the Scrivener's error, is that along that strip in front of the pink and in front of the purple and in front of the green, you can in fact develop the dune environment there. And that's what I was talking about last time I spoke at your last meeting. And if you go down and look at in front of what looks more like a 5-story building, even though I know it's zoned to 4 stories, that's actually going up with timber resorts. They have destroyed all the way out to the edge of the sand. They're in the dune line, and Kika does not own that strip there. That was part, except for right in there, but you're getting rid of those development rights. You're selling them to KP, or you're exchanging them with KP, and then they'll be able to develop on that dune.
Kiowa Partners will not be able to develop seaward of the setback line.
Well, seaward of the setback line, but how about just like we're going to do here and take out the dune here for the
It's
swimming
all
pool?
landward, it's all landward of the setback line.
So the dune, which has habitat value, which the Conservancy seems to not give as much value to as the marsh, will be developed in front of the pink area that's on that map. Is that correct? Or can, maybe,
Boardwalks and gazebos.
and swimming pools?
No.
Well, then why is there a swimming pool in front of, why is Timber Resorts in front of the green having swimming pools and things, and why are we gonna have a swimming pool? And why is the inn gonna have a swimming pool on the dune habitat?
You'll have to show me a plat that shows a swimming pool seaward of the setback line, because I just don't believe that's the case.
But the setback line now ends where the dunes end, correct?
The setback line meanders up and down the beach. I mean, if you look at the deed that conveyed this piece of property to the community association in 1996, the language, the property description actually says a piece of property roughly 10 miles long, between 200 and 300 feet wide, and it's a dynamic environment, as you know. In fact, your boardwalk 1, we don't think we're going to have to chop it off.
Oh, I know, except that it got rained on.
I had a property owner just email me a question asking for clarification on something that you said earlier, Dick.
Yeah.
And the question is, did you say that we're voting today because the Conservancy felt it was too big a decision for your board to make?
When we got to the situation of trying to make a value judgment about whether the parcels at the entranceway were developable, and that is a decision that a lot of people can go back and forth and have a discussion on, in the various monetary values that may be associated with that. We have an opinion based on our negotiation independently with the developer that it has a significant monetary value to the developer. And for us to roll the dice and say, no, that is not going to be developable, was not a risk that we thought was prudent for the Conservancy to take for the town. And at that point, when we became aware of the negotiation between the developer and the community association, we then recommended to them that we put the two transactions together and present the town with this opportunity to make a decision about the future of the entranceway.
Good morning, my name is Dick Murphy, and I live at 60 River Marsh. And one of the things that I got out of the presentation that you did, Dick, both of you actually, is you provided more information, right, than what's been in the write-ups, i.e. some of the residual values or past values of the initial rapid development in some of the other locations. One of the things that I think would move that 32% in terms of the participation is a balance sheet approach. If you took all of the things that are in it from the Kika's perspective and listed them down in a balance sheet, put a value against them, excuse me, you would come up with a number. If you did the same thing with the parcel in question, you'd come up with a number. Based upon what you said, it sounds like it would be an overwhelming case, but the way it's presented right now, you don't necessarily see it that way. So my proposal to you would be, can you put together a sheet that gives you a valuation in monetary terms of what all the parcels in question, and then we can sit back and say, hey, that's a hell of a good deal, which they don't necessarily see when they start looking at individual parcels. Thank you.
Rich Gayton, 602 Piping Plover. Just, I'd like to get your thoughts on if this is vote, the vote is no, what do you think the probability the partners are going to build on the entranceway is?
We thought it was high enough that it required the town vote.
So, I'm just trying to get, I know this is a complicated issue, as simple as possible. At the end of the day, the vote is where are the partners going to build? Are they going to build in the entranceway, or are they going to build on that pink piece of parcel land?
Or both, depending how the situation goes legally. If they win the court case on the pink, they can build on both.
Got it.
If you have a no vote.
Okay. Thank you.
I mean, it's impossible to put a percentage on things, but when you have property that is zoned for development, has development rights, my gut is some developer, whether it's this one or another one, will do everything in their power to monetize those development rights.
And I would add that if you think about this over a longer period of time, when the prior developer was here, he lived on Kiowa. So you have a particular perspective and value that is placed on the community that he's going to leave to his children and grandchildren. Townsend has been involved in the community for a long period of time before the particular developers come in. I've been working with him for a half a dozen years. And in the initial part of the conversation, it was kind of a clear conversation. I understand that your company is here to make money, and you understand that the Conservancy is here to represent the community from a conservation value perspective. Now, given that we understand each other's interests, are there some common areas that we can work together to create some value for Kiowa? From the Conservancy's perspective, what's going to be the balance between nature and development on the island? And from the perspective of the developer, is the better the reputation of this island, the easier it is to sell property. And that's the relationship we've had over a period of time. Now, the condition that's changed is that some of the decisions are being made by people in New York. They're not being made by people on Kiowa. So they're more interested in that dollar sign than perhaps some of the earlier people are. And that's one of the things that changed our perspective on we need to allow the town to make a decision about the entranceway, not a group of people who may be trying to think about what's good for the community.
I had a couple questions that were submitted. First is, what does common property mean? It's actually a defined term in the Community Association Declaration of Covenants and Restrictions. The Community Association owns 3 types of property on the island: common property, purchased common property, well, there's another term, restricted common property, but we don't hold title to any restricted common property. It's essentially a defined term that talks about who can use the property and who pays for it. It's in the declaration. If you're suffering from not being able to sleep, read those definitions and covenants and restrictions. Second part of that was, what does conveyed as common property mean? Whenever the developer conveys property to Kika, included in the deed, it says this property is conveyed, and lots of legalese, and it will say to be used solely as common property. The second part of this question, does it mean that Kika, as a result of the most recent court ruling, has full access to the beach parcel and cannot be prohibited from using or developing it for the benefit of all members? Well, the linkage, there's no linkage between its being common property and access. The two are discrete issues. Next question, if the judge did not consider the 1994 agreement determining ownership rights, would the judge and court consider that agreement for development rights? Not sure I completely understand that question. Are there legal opinions or letters from counsel on that point about what rights KICA has with regards to development? I think I talked about that already a little while ago, that, you know, the advice of our legal counsel, who has been involved in this issue for probably close to a decade, is that certainly KICA can make challenges on these various points, but the outcome is totally unpredictable. It's going to be a long, expensive process and so forth. And I think the last bullet is a similar question. So those are some questions that we had submitted. If there are questions that come up after this and you'd like to ask them, send them to justask@kica.us. Our organization, KICA, receives on average about 65,000 emails a month. We try to respond to each and every one of them within 24 hours. I think we may have received 65,000 emails in the last 2 weeks. But that's what it's there for. And it's not just about this. Anything KICA related, if you're not sure who to talk to, just email justask@kica.us. We do have a couple of board members here today. Our chair, Dave Singer, is right here. Another board member, Kathy Pumphrey, is back here. And certainly myself, Dave, Conservancy trustees, all of us are happy to answer questions on this proposed transaction. Another question?
Hi, Chad Cook, 167 Bluebell Court. Sorry for the late question, but it's been proposed that these 3 bits of land, including Rabbit North, Mingo South, Mingo North, is the protection area for the entrance in terms of the beauty of entering the island. The option to purchase here, can you describe what are the details behind the option to purchase and what your expectation might be if it's going to cost us money, and the option to purchase is a result of a right of first refusal, for example, and someone determines, gee, I think I'll pay $5 million for that. Now we have to come up with $5 million to offset that. Or what are the terms and conditions behind the option to purchase?
So I mentioned that this has been a complicated 3-way negotiation, and part of what an additional layer of complexity is there are actually 2 deals. There's a proposed deal between KICA and Kiowa Partners, and if the vote is successful, it triggers the activation of a second deal between the Conservancy and Kiowa Partners. And that's where that option to purchase is, and I'll let Dick speak to that.
So we do have an option to purchase at a bargain sale price. We do know, the Conservancy knows what that bargain sale price number is. We have a valuation in our mind based on market appraisal of what the market value of the property is. But my negotiation professor in college told me, don't hold a negotiation in public because you're giving the other side of the discussion information that they can use in a negotiation. So with respect to the question, the Conservancy would prefer not to put the number into the public domain.
But it won't cost KICA members anything. This is a Conservancy.
Correct. This is, the Conservancy has to do a fundraiser.
What are the terms and conditions of the option to purchase?
6 months, we have to raise money through donations or use of a line of credit.
How confident are you you'll get it?
105%.
And you're going to buy it. So KICA doesn't buy it.
Correct.
So there's no financial output
Correct.
from KICA for that piece.
Correct.
And you're confident, 105, fairly large number, that's going to happen.
The ex-chair of the Conservancy is standing in the back of the room, and I don't hear him waving his hands. I think I kind of see him saying, yep, he may be a little low in the probability.
So you're gonna buy that, and we're sure that you all are gonna do that.
We wouldn't have, this went 3 times to the Conservancy trustees for their approval to move ahead. The last time when it's, okay, we got the arrangement in place, we're really serious about this, you need to vote. And oh, by the way, if you vote yes, the quid pro quo is if this is a yes vote, we're gonna go after and we're gonna raise the money for the option and successfully close this deal. The vote of the Conservancy trustees was 21-0 to proceed.
I don't know, why wouldn't that, all 3 of those pieces be put together? And I wouldn't even have that question then, right?
Because
all 3 of those pieces were part of this deal.
Because the developer was not willing to put the 3rd parcel into the transaction. And in fact, 95% of the way through the dialogue, the developer recommended pulling the piece that is in the crosshatch out. At which point the Conservancy said, you pull that piece out and we're out of the transaction. And the recommendation to the Conservancy, from the Conservancy to the developer and the community association is that without the support of the Conservancy in this transaction, you will not get a 75% vote. And it was put back in again. So we think we got to that point in the negotiation where the point of hurt was reached.
No chance for that ever to be developed if we vote yes.
Assuming that we raise the money for the option, and I've given you the probability in our minds of the ability to be able to do that, correct?
Assuming, okay. So that's a definite maybe.
I was trying to be a little more than a definite maybe.
Okay, one last question. Would you go back to the little pink map? The one with the little pink thing in it? Yeah. And you said there's no access, there's no value to that to Kika because there's no access to it.
That's only part of it.
What?
That's the least part of it.
Yeah, so in looking at that yellow road and the pink piece, they seem to touch. Can't you enter that or have access or easement to that from that
The
upper
edge
left corner?
The edge of that platted right of way is about 5 feet from the corner of the pink parcel.
Right.
And I think the edge of curb is like 14 feet from or 15 feet from the pink parcel. Access is currently a challenge. As I've already said, I think that there's a decent likelihood that Kika could get access, but that's not our biggest issue there. Our biggest issue is the inability to develop the property or sell it to a developer because we don't control the development rights. The development rights are conferred by development agreement between the town and Kiowa Partners. And until Kiowa Partners assigns those development rights to someone else, Kika has a piece of property that it can't find a buyer for.
So you're saying you can't get access because it's 5 feet of protected?
No, that's not what he said.
What did he say?
What he said was the reason the value is not there for Kika is because we don't have development rights. Access is also a problem, but that's not the key problem. The key problem is development rights. That's why there is no value to Kika. The financial value to Kika isn't there. The issue with development access is a separate issue, much less important than the development rights as it relates to value.
Okay, maybe. I'm not sure I agree with that. At least there would be some, if there were accessibility to that and development rights could be put together, then thered be great value.
Oh, totally.
Yeah.
Sure.
Thank you.
I want to get back to process and contacting people. While we're sitting here, a Kika newsflash came in talking about a meeting with the nominating committee on September 11th about running for future boards. And I don't question the importance of that, and I'm glad Kika is seeking people to demonstrate interest. But right now, we have this critical issue before us. People are voting as we speak. And I just don't understand why this isn't being used to get to property owners and urge them to vote, however they vote, urge them to vote so we can make a quorum.
Wendy, I assume you read the second article in that newsflash too that talks about this vote that's underway. I failed to mention in my earlier comments about the ways that we're reaching out to people to remind them to vote. But once a week, the votenow.com, which is the third-party voting company that we use to administer our elections, sends an email reminding people to vote to anyone who has not yet cast a ballot. So we're hitting folks at least weekly through Kika's communications channel. Vote Now is hitting folks with an email, and at least they only hit the people who haven't voted. So I understand your perspective, but I think it's pretty clear in that e-blast that I approved, I think about 5:30 this morning. I looked at it and made sure that there was significant verbiage on this transaction. I do want to just kind of, Dick talked about sort of a balance sheet, and I'd like to wrap up by kind of talking about what does voting yes mean and what does voting no mean. Voting yes means permanent, guaranteed protection of the two parcels in yellow. Ensuring that there's no development on those parcels, regardless of how difficult or expensive or what have you that it may be to develop them. It takes that issue off the table completely. Voting yes gives the Conservancy, it guarantees the Conservancy the option to purchase the parcel in blue, and we think they have a pretty good chance of raising the necessary money, taking another 19 units permanently off the roll in terms of possible development. Voting yes guarantees that 700 acres of marsh, regardless of how much you value that to this deal, it guarantees that will be available for research and so forth by the town and the Conservancy and others. It guarantees that there is a deed restriction on this pink piece of property preventing vehicular access to Captain Sam's. Voting yes guarantees that Kika acquires some operational parcels that are really important. Parking for members at our community center, parking for members to go to the beach, storage and parking at our maintenance sites so that we can make sure that we keep those operations on the island and don't have to risk taking them off island at great expense to the community. We lease a significant portion of our maintenance site from the developer for $1 a year. They can throw us out with 90 days notice. Voting no means Kika keeps the pink parcel that we can't do anything with. Voting no does not protect the entrance to the island. Those parcels can be developed. Voting no keeps all of that marshland in someone else's domain for decision making. And voting no means that we don't get any of those 6 other parcels that I mentioned. So to me, that's the analysis right there. And so would like to thank you for coming today. Certainly thank the folks that are online. As I said, continue to keep those questions coming. Like I said, 65,000 on average a month. It'll be interesting to see what this past month was. But thanks again. Appreciate you being here.
Thank you.